officers at the airport search a person's luggage? Hey guys, my name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing the Roadside Chat. All right, so this question comes from an officer in Texas, right? And the officer says, look, I've attended your instructor class, and we talked about a case called Jones, where, trespassing on a person's property may be a search in the Fourth Amendment. So my question is, look, we have officers that go to the ramp for incoming flights. And it's brought up a few issues, and so regarding consent and questioning and so forth. So the question is this: look, if we go to the ramp, where the airline works and unloads, and the airline is unloading those bags to put them on the conveyor belt, right? So they go to the main terminal. Now, these ramps are not in public locations and only accessible to badged employees. The officers have been removing the bags from the baggage claim to check the baggage tag, weight, zipper location, and odor. They've had several rather large busts with marijuana, and so forth, and this become a hot topic. So a few of us are concerned that this activity may be a search under the Fourth Amendment, and if so, it would need a recognized exception like exigency, search warrant, consent, and so forth. All right. Well, look, let me kind of go through this, right? The first thing, rule that I want to kind of share with you is that, look, as long as the police don't do anything more than what the airline should do, then I don't think a search occurs, right? This is not going to offend the Jones case. So what happened in Jones is that the government put a GPS tracker on a vehicle. No warrant. They tracked that vehicle for about 30 days. They used that tracking information in a warrant, and narcotics were found. Okay, so the Supreme Court said that even if the driver had no reasonable expectation of privacy in their public whereabouts on public roads, a search still occurred because the government trespassed onto a person's property, protected area, right, like the car, with the intent to gather information. Well, is a trespass occurring here, right? When the police lift up the luggage and move it, is that the kind of trespass that we're talking about? And the answer actually is no, right? Because there's also no seizure here, right? A seizure of property occurs when police intentionally interfere with an individual's possessory interest in their property. In other words, they're kind of mess with people's property in a way that's not expected or agreed to. I know but Anthony, the airline passenger did not agree to the police to touch the luggage, but the point here is that it's not that in the weeds, right? The point is when a person hands over their luggage to the airline, do they expect it to be lifted up? Do they expect that the tag will be inspected, right? Do they expect all that stuff? The answer is yes. They're agreeing to that. So when the police do it, it's not trespassing on a person's Fourth Amendment rights. And that's why this is not going to, in my view, we can debate this in court, but in my view, this is not going to actually be a search under the Fourth Amendment. I also have a case from 1988. It's way before Jones. But, let's look at what this case says, right? It says, we recognize that when airport security concerns are not implicated, every passenger who has luggage checked with an airline enjoys a reasonable expectation of privacy that the contents of that luggage will not be exposed in the absence of consent or a legally obtained warrant. So it's not like the passenger has no expectation of privacy. It's just that it's a little bit more limited because they expect their luggage to be handled and thrown around a little bit, right? That reasonable expectation of privacy, however, does not extend to the airspace surrounding the luggage. Therefore, we held that the use of a trained canine to sniff the exterior of luggage did not constitute a search. As a result, we concluded that the reasonable and articulable suspicion is not required before a DEA agent may use a canine trained in drug detection to sniff luggage in the custody of a common carrier. Well, this also implies that the DEA can actually lift up the luggage and move it and inspect it. Now, what would cross a line? How about squeezing the luggage, right? To smell it, Do I believe that is a problem? Absolutely. Is there a case in the Fifth Circuit that says it's okay? Yeah. Did they get it wrong? Yeah. Especially now after Jones. That case was decided before Jones, right? But squeezing in order to expel air out of a bag would be a trespass because the person who provide their luggage to the airline to check in their luggage does not expect and consent to that, right? He's not expecting the airline's going to be squeezing the luggage to expel air to start smelling the contents. He's just expecting that's going to be put on a conveyor belt. So I just want to let you know that. So if that's what's going on at the airport, I would not do that. But moving the bag, inspecting the exterior, looking at the tag, feeling the weight, putting it on the ground for a dog sniff, that's all permissible after Jones, right? I hope this helped. All right, guys, keep the questions coming. I hope this is a very good topic, right? Definitely a good topic. So keep the questions coming. Hopefully this has helped you do your job lawfully, get it right every single time. All right? Until next time, my friends, stay safe.